checks and balances and ensuring the liberties and rights and the functioning of government according to law. And General Beshear has done an extraordinary job of that. And so I'm proud to introduce him as our next speaker.
Thank you. I needed that decision. Thank you very much, and I greatly appreciate that decision, which also became a large part of the holding in one of my favorite cases that goes by the name of Beshear v. Bevan. Folks, my name is Andy Beshear, and I love serving as your Attorney General. As the Attorney General, my job is to be the guardian and chief protector of our Constitution. And while all public servants are supposed to fill that role, we see how few currently are. As many of you all know, we have an oath in Kentucky when you take office. It has two parts. First, that you haven't fought a duel, or been a second to a duel, or issued a challenge of a duel even if you didn't fight it, and I'm doing okay on that one thus far. And second, that you will uphold the U.S. and the Kentucky Constitution. The bedrock of that Constitution is our separation of powers. It is how our founders ensured that they would never be ruled by a king, no matter what he calls himself, ever again. The founders of this country wanted to create the types of checks and balances that would make sure that no one individual or no one branch of government could exercise tyranny over our people. So it created a government with three separate branches, and some forget that those branches are co-equal, each with separate duties: the executive, legislative, and judicial branch. And at the same time that our country was forming these branches, our states were creating their own governments. Kentucky, like many others, followed that national model in creating three additional branches. But here in the Commonwealth, we were even more concerned about potential tyranny on the state level. So we not only created a separation of powers, but we made it some of the most powerful in the country. Multiple Supreme Court decisions talk about Kentucky's separation being the most powerful in our country, in that we have not one, but two sections of the Constitution. One that creates it, and one that absolutely prohibits any other branch from exercising powers delegated to another branch. But we took another step, and that's why I'm standing here in front of you today. In the federal government, our executive branch only elects two members, the president and the vice president. They appoint their attorney general, something our current governor, I hear, is interested in. But we're seeing right now, and we've seen in the past, some of the major concerns that can arise out of that. In Kentucky, we wanted to make sure that our executive branch had its own separation of powers. And so we created not two, but 7 independently elected constitutional officers. The Attorney General is one of those, and thanks to 2,201 votes, I get the opportunity to serve. But the Attorney General, based on Supreme Court decisions, not only has the opportunity or the standing, but the duty to enforce the Constitution. That was first decided in Paxton, where the court said that when an unconstitutional piece of legislation, like the current so-called pension reform bill, is passed, the Attorney General not only has the standing, but the duty to challenge it. And then just a couple of years ago, in that Beshear v. Bevan case, Supreme Court further decided that when an executive branch actor oversteps, violates that separation of powers, commits an unlawful act, that the Attorney General again is duty-bound to stand up to that for that Constitution and against that action. And thank goodness we created a government with that separation, because right now in Frankfort, we have seen the worst of government. Over the last 2 years, we have seen our separation of powers attacked day in and day out, and we've seen the exact importance of the office of Attorney General. In the first act, this governor illegally cut our higher education, our public universities and colleges, despite the fact that he was left a surplus. Under the law, any cuts require a deficit and then must follow what is called a budget reduction plan. So when those illegal cuts were made, we filed suit. In that court action, this governor argued that the legislature, the General Assembly, doesn't actually decide how money's spent, that their appropriation power only sets a ceiling, and that the governor and the governor alone decides how much any one branch of government gets, any one office, be it prosecutorial or judicial, gets from zero to the ceiling that was set. We fought that very dangerous argument in court, and we won. But those actions have continued. Just 6 months after, we saw a governor reorganize the board of the University of Louisville. That board had been created by statute to provide for independence for that university. It had created set mandatory terms so that once someone was appointed, that they owed their fiduciary duties to a very important university. It staggered those terms so that no governor could appoint an entire board all at one time. And it set very specific requirements that anyone sitting on that board would have to meet. Well, in the stroke of a pen, a governor dissolved, fully purged, and appointed all members on one day. And what happened? Our university was placed on probation by its accreditor. A black eye that, while the university is now off, will stick with it for a long period of time. And that was a black eye that university did not deserve, because they did not commit the action that got them that suspension. So we took them to court, and while the Supreme Court ultimately ruled that the legislature had bailed the governor out, it made a very important holding, that the governor could never use that reorganization power to impact a university ever again. It means in the future, not only is this university protected, but every other public university and college across Kentucky. But just like the higher ed case, that was a violation of the separation of powers, because the legislature, through statute, had specifically set out how that board was staffed, how long the terms were, and had provided for its independence. The same violation. Then just a couple months after that, the governor did the same with our Kentucky Retirement System Board, and we've seen the consequences. What he did is he took a board that was stacked equal number, elected from retirees and appointed by the governor, and gave himself 4 more votes. Those votes have resulted in failure to produce actuarial analysis whether or not initial bills would work under some of the worst theories that we've ever seen under the Open Records Act. It's resulted in decisions that are highly concerning being made in the future, and has resulted in a board actually supporting an illegal and unconstitutional pension bill. So we took that to court. And again, while the legislature bailed the governor out, the trial court made a pretty important ruling. It said, thankfully, the governor has acted again with regards to education boards, and we believe that the Supreme Court will address it at that time. What they were referring to is our 4th action to preserve the separation of powers. When the Kentucky Department of Education, the EPSB, and numerous other education boards were once again reorganized and statutes rewritten. Executive directors that were independently chosen by those boards were now appointed by the governor. All the members were purged, new members were put on, and the criteria in which your elected officials decided that people would be selected was entirely rewritten to the discretion of one man, the governor. So we filed suit again, and that is currently in front of the Supreme Court. That violates the Constitution in numerous ways, not just in that it invades the province of the legislative branch, but that under our Constitution, our education system must be maintained not by the executive branch, but by that legislative branch. It's why in the Rose case, the court, in making its decision, provided orders and guidance solely to the General Assembly, because it is their duty to maintain our system of education. So when a General Assembly provides for how a Board of Education is supposed to be put together, how a school district is supposed to be put together, how a school district is supposed to be run, and the executive branch, through the decisions of one man, the governor, comes in and tries to rewrite that, you can bet the law is broken in that course. And our appellate brief was just filed last week. We've actually put it up online so that everybody can see it. But that brings us to the most recent action where the separation of powers is so critical, and that's with this so-called pension reform bill. As many of you all know, decades ago, our General Assembly made a promise to our state workers, to our teachers, to our firefighters, to our police officers, to our state and county workers, that if you dedicate your life to public service, because it takes decades to qualify for a pension, if you dedicate your life, sadly, we won't pay you enough, but we will guarantee you a secure retirement. They not only made that promise, they turned it into a contract. Then they passed that contract into law, and when they passed it into law, they made it inviolable, meaning it could never be broken. Just recently, in the dead of night, by turning an 11-page sewage bill into a 291-page pension bill, they broke that promise. Not only did they violate the Contracts Clause of the Kentucky Constitution, which supports the rights in contract of every public worker, they violated numerous provisions of that Constitution that govern how legislation must move through the General Assembly. Because our framers, just like when they set up that separation of powers, knew that the legislature, if not checked, could do some really terrible things. So they created a process where you, the public, would never be shut out. They created a requirement that any bill that would be passed had to be read 3 times on 3 separate days. They said that any appropriation, anytime we're going to be spending money, it took a vote of the majority of both chambers. And they said you could never pass a pension bill, this is in statute, without having an analysis of whether it works. Well, what did our General Assembly do? In the span of 6 hours, they turned a sewage bill into a pension bill and passed it through both houses. They did it in a side room off of the House chambers where the public was excluded. They allowed absolutely no testimony, and at the time they did it, they didn't even have an analysis of whether it would work. Well, thankfully, our separation of powers creates an independent attorney general whose job it is to file suit to void unconstitutional bills like that pension bill. And in doing so, we believe that we will not only be able to stand up for the rights of our public servants, but we will be able to give you the type of government that you deserve. A legislature that never again acts in secret in a side room. A legislature that never again turns a dog-biting bill into a University of Louisville higher education bill, a well digger bill into a taxation bill, and a sewage bill into a pension bill, and rams it through without you being able to stand up for yourself, make yourself heard. But I gotta tell you, while we have seen the worst of government, while we have seen more violations in the separation of powers in 2 years than I think we've seen in 2 decades, I see hope. I see democracy. Because after the people were wronged, after that pension bill was snuck through, 12,000 people descended on Frankfurt. They demonstrated peacefully to let their government know that those legislators and that governor still work for them. And while most of those legislators and that governor hid in their office, I was proud to walk through that crowd, to let them know that both I and all of the elected officials that are here today know that we work for you. Our job is to make life better for your families. My mission is to make sure your family can live in not only a safe neighborhood, but has a real path to prosperity. And so as we move forward, I hope you realize that we are in a battle for the soul of our Commonwealth, that we have to take our government back, that we have to be heard, that the folks we send to Frankfurt work for us, and if our families have to follow the law, so do they. And until we can get you that government, I want you to know that I will be there every single day, fighting for your rights, standing up for that Constitution, and making sure everybody, even the governor, follows the law. Thank you very much.